Good afternoon and welcome to Vann Attorney's webinar. We are really delighted to spend this time together, and we look forward to talking with you about contract provisions that really do matter, especially in light of the circumstances that we find ourselves in now. Just for a little bit of homework, if you want to submit questions, you may do that either using the control panel on the GoToWebinar on your screen, or you can submit those by email to webinar@vannattorneys.com. I'm James Vann. Ian Richardson and I practice law together, and we're going to be talking today about contract provisions that really do matter and why they're important to you now. In light of the issues we've been looking at with the coronavirus and so forth, these provisions really have come into really being more applicable today than they probably have been in a long, long time. So we're going to look at how the current economic conditions impact our business contracts, what contract terms might come into play, and then how might this impact accounts receivable. So those are just sort of the topics we're going to be talking about. And so I know a lot of y'all have already participated probably with webinars. You've already seen emails and other documents that talk about the issues that we're going to be talking about today. Hopefully this will enlighten you some more with what's going on with your contracts, with your customers' contracts, and how this might impact your business. Hopefully getting ahead of it, understanding a little bit more will help you. And there's a term called force majeure that quite frankly is in a lot of contracts. You may not see those words or those terms, but it's almost probably inevitable in most contracts. So that's just part of most contracts you'll see having to do with whether or not the parties are obligated to perform. But that's obviously, those words are not something that you normally hear a lot about, and you don't litigate it very often.
Yeah, I remember my 1L contracts class that was about 9 years ago, and we glanced over that, but it wasn't really something that was important.
That's right. So what does it mean? Well, it means an unforeseen circumstance that prevents someone from fulfilling a contract provision. And it's a contractual provision that protects the parties, obviously, in an event that, say, part of the contract for some reason can't be performed due to some cause which was outside of the control of the parties and could not be avoided by exercising some form of due care. Now, that's the Black's Law Dictionary definition, and that's still a fairly applicable definition of what that provision provides for. But again, it's to protect the parties from something that they didn't expect to happen, and it's really outside their control. For example, you think about 9/11. I mean, that's obviously was outside of everybody's control. You didn't expect it. There was an act of terrorism, and when you use those words, and when the president says, in that case, we're at war, does that really mean we're at war, or is that used in a different format? And are we declaring war? So those kinds of things will come into being. We're going to talk a little bit about them today. And then how's it used? Well, often it's used to excuse the contractual performance of one party to another. So somebody's using it somewhat as a defense sometimes, or they may be using it as an offensive way to say, hey, look, I can't perform this contract, so I need to stop. And so those are sort of the ways that they're used. There's really no standard or common boilerplate necessarily that you'll find. I mean, sometimes you'll see that in some provisions in contracts, but there's really not a standard boilerplate. You really need to read the specific contracts. I asked Ian when we were putting all this together, I said, can you if you found any? He found me one that he had seen recently, and I found a few, and so, but they're all different.
They're all different, and I think they're all kind of fact specific. So the language of your contract is going to be really important.
Yeah. Yeah, you bring a good point up, Ian. It is very fact specific and also industry specific. So you really have to. We hate to tell you, but you really got to read the contracts, pretty much all of them, to get an understanding of it. I looked at a few contracts of some of our clients that I know that where we've helped draft before, when they're handling different types of equipment or product, and quite frankly, that language varies, again, depending on the industry. So it's something that it may be negotiated, and it's not something that's usually fought over a whole lot because most people think it's never going to happen.
Yeah.
So that sort of gives you a little bit of an idea with how it comes into being. Excuse me. So some sample wording that we've got here is, for example, it's when a period of time is here and prescribed for any action to be taken by, in this case, the plaintiff, that as applicable, shall not be liable or responsible, and there shall be excluded from the computation of any such period of time. And here's the issue. Here's the things that they, in this case, they provide for any delays due to strikes, riots, terrorism, acts of God, shortages of labor materials, war, laws, regulations, or restrictions, inabilities or delays in obtaining governmental permits, causes of any kind of cause of action whatsoever, which are beyond the reasonable control of the plaintiff. So, Ian, when you look at that list of the things that in this case are prescribed as that might kick up that them being able to use this language, what source is evident to you that that could be in play at this point?
Well, the one that I would go to the most if I was approached by someone that wanted to try to enforce this would probably be the regulations or restrictions. I think it's fairly easy to argue that with all the orders that have come out from various governmental entities that we've got new regulations and restrictions that we didn't have several days ago.
That's right. You know, you think about what about acts of God? Obviously, we're going to be talking about that in a little bit, but some people will say, well, this is an act of God, and therefore I don't have to comply with my contract.
Yeah, exactly.
Or, you know, there's a shortage of materials now because, say, China was shut down. I had this question earlier. This group was ordering light fixtures, and light fixtures were not being shipped over as quickly due to the issues in China earlier. So, the question would be, if this type of language was in their contract, would this give them a reason that they wouldn't have to comply? Maybe so.
Yeah.
Again, you got to sort of look at the whole contract, but maybe so. Interesting enough, I talked to a shipper yesterday out of Wilmington that helps companies ship product both ways, overseas, back and forth. And I said, how's business? And he said, well, we're not burning it up right now. He said, but thankfully we're not stopped either, which I thought was a little interesting. I figured that was going to be picked back up some, but in reality, and they bring a lot of product up and down the southeastern, or all up and down the east coast of North Carolina and the U.S., but also in California as well. So they're feeling the issues there on just the boats coming back and forth. So so another example of sample wording would be what you see on the screen now.
Yeah, so this one says, should performance of any obligation created here and under of this contract become illegal or impossible due to, and then it gives another list like we were just looking at. I think it's interesting that this force majeure clause has illegal or impossible because that's really kind of the crux of the issue most of the time. If you think about the governor's order here in North Carolina, for instance, that order has made it either illegal or impossible for certain businesses to operate. And this kind of gets into that fact-specific inquiry of, well, are you dealing with an essential business or a non-essential business, which are really things that we didn't think about that much a month ago. But now it's critically important. And I think if you're trying to enforce one of these provisions or enforce other provisions of your contract, that's something that you've got to look at if this contract is here, because if you're dealing with a essential business, I think one analysis might happen, and if it's a non-essential business that is in fact shut down by the government, we have a whole nother set of issues to deal with. And then it's also important to note that you do have some obligations, even whenever there's something like the coronavirus going on, to act in good faith and to really try to remove any hindrances to your performance. So that's in sort of the last part of this clause. It talks about remove the cause preventing performance. Obviously, you're not going to be able to remove the coronavirus, but if there's anything you can do in your business, I think the wise decision is to try to do everything you can to still perform, even if you might be able to rely on one of these contract provisions.
And Ian, that's a good point. You know, we've all seen companies or individuals in a contract get to a situation and sort of sit on their hands and go, you know what, I think I've got, in this case, I've got an issue that I can get out of performance for, so I'm just going to sit on my hands, where I could have really probably tried to get around it, and I might have been able to do it. You know, so you got to think through that a little bit as well.
I think if the approach is to sit on your hands whenever you could really do something, that's probably going to invite litigation, and it's probably not going to work out very well.
Yeah, that's a good point. So another sample here is, without limiting any other provision in this agreement, in this case, the company will not have any liability for any failure or delay resulting from governmental action, fire, flood, insurrection, earthquake, so forth, strike, so forth, beyond the control of the company affecting production. So, you know, I look at this and I think governmental action. Okay, let's just say the governor or the president, right, says put some limitation or restriction in place, and they can't perform. You know, would that trigger this provision so that in this case they wouldn't have to comply with it with a contract? Again, I hate to keep saying it, but it really depends on the contract, the whole contract. You got to look at what they're supposed to do, when they're supposed to do it, how they're supposed to do it, and is that outside the control of the company, affecting the production or delivery in any manner. And then, you know, does it just delay it, right? Let's just say in this case where, let's just say it's the end of April, that, you know, the governor's order in North Carolina says through the end of April, but you can start back in May 1, and that would still comply with the contract. You know, question would be, well, you just need to start performing on May 1. And then you got some other issues you got to deal with on that. So
yeah, I think the advice I would give is probably you do need to start performing as quickly as you can. But I think what we're going to see a lot of are businesses that get shut down for whatever reason. Either they can't get materials or they just can't have their workers go in to do work. And that might put them out of business. And that's when I think these clauses are really going to become interesting.
Yeah. We were talking ahead of time, and Michael Fernald, as part of our office, we were just talking. He helps a company that does embroidering on a larger scale, and you know, let's say they had an order for 10,000 shirts that were embroidered or whatever it may be, and the buyer says, hey, look, I can't buy it, right? I can't accept this because I can't turn and sell it. And whether or not they would ever be able to use that kind of language or not, it'll be interesting to see. I've got a friend who makes T-shirts up the street. They do screen printing on T-shirts, and I know they've had a lot of contracts that are delayed or either canceled. And so, again, it's going to be what the contract says. I haven't looked at the contract yet, so I don't know what it says. But you know that's going to happen.
Right. And whenever you've got contracts like that are canceled, we have this issue we have to deal with. Well, obviously, the people would have wanted the items if things were going well. So is it even really worth going after them? And,
right.
There's a good reason they decided to cancel the contract.
That's right. Yeah. All right. So here's some more sample wording.
Right. And the first few on this list, so flood, fire, storm, earthquake, these are what I think of as kind of the law school examples that we all were really thinking about. Some type of natural disaster that comes through, and North Carolina hurricane's a good example. I can't think of another situation where governmental authority really came into play, but that's certainly one that is at issue with the coronavirus. Strikes or labor shortages, those are certainly at issue. Act of terrorism, that is more the 9/11 example as opposed to what we're dealing with here. Governmental authorities have talked about how this is a war. I don't know if you could actually rely on that. I don't know if we're really at war with a virus, but that's probably not the first one to go to. Natural disaster, I think that certainly encompasses some of the other ones on the list. An act of God. I'm going to talk in just a minute about whether this is an act of God and whether that's necessarily the best provision to proceed under. Most well-drafted clauses are going to have a catch-all phrase that should encompass what we're dealing with right now.
Yeah. And we were talking the other day in the office about business interruption insurance. We don't have a slide on it, but I just want to talk about why we're here. So some of y'all may have business interruption policies in place, and I would tell you, you got to go to the policy and you got to read it, the whole thing, to figure out whether or not that would kick up. But some of those policies, Ian, you were saying the other day, there are exceptions to those, or actually there are a lot of exceptions.
Yeah. In fact, one of the trade organizations I belong to has been having a conversation about this, and the only policy so far that anyone has found that cover this type of thing are written by Lloyd's of London. All the other policies have exclusions for viruses. So even though this virus is interrupting folks' businesses, their business interruption insurance is useless, which is really unfortunate.
But again, before you assume that, look at your policy and make certain, because some people could have old policies that haven't been updated, and there's not an addendum to it to change it. So make sure you look at that if you need to. So this was a North Carolina court case note that we pulled up regarding force majeure, where it said the defendant also asked the court to consider that it did not have plaintiff's documentation prior to the time when October and November rents became due. The defendant pointed out to the force majeure provision in the party's lease, which allows an extension of time for performance by the tenant when the tenant's ability to perform its obligations under the lease are delayed due to a cause beyond the tenant's control. So that's the wording that the North Carolina court used in the actual case. So no doubt we're going to see people and companies try to use this to their advantage, right? And obviously there's some that's justified and legitimate, and there'll be others that are just trumped up and try to be made up. But it's something that we need to think about. And in this case, I can't remember what year this case came out, but it wasn't all that long ago. But so there's just something to think about to go as we go forward. So let's look at acts of God. And that's something we have probably seen in contracts before, but never really dealt with a whole lot.
Yeah, and that's something that I will have lawyers occasionally call me and try to suggest that some problem that's occurring on a building project or whatever is an act of God, when in fact that's not the case. But that's actually something that is defined by Black's Law Dictionary. It's an event happening or occurrence due to natural causes and an inevitable accident or disaster. And it's an act that's occasioned exclusively by violence of nature without the interference of any human agency. So what I think is going to be interesting about this virus and this act of God defense is as we learn more about this virus and how it's spread. We talked a little bit earlier about how this inquiry is so fact specific, but as we learn the extent to which man has had anything to do with this situation, I think the more man has to do with it, the more the act of God defense goes away. So there are theories floating around out there that this is a man-made virus. Well, if that is proven to be accurate, and I have no idea whether it will be or not, then the act of God defense, I think, necessarily goes away, which is kind of a lawyerly argument, but it's just something that is going to be an issue. So if I were advising someone, I would probably tell them, if we've got something else in a force majeure clause other than act of God we can rely on, this is probably not something that we should just rely exclusively on that. We can throw it in to the discussion, but I think there are better examples in some of the other clauses we've looked at other than an act of God.
So the definition that you see on your screen right now actually came from a U.S. Supreme Court case. And Ian and I were talking about it the other day. We're just sort of going through this. So you think about this just for a moment. It's an act of God, right? It's an act occasioned, and this is what the law says, exclusively by violence of nature without the interference of any human agency. So, being lawyers, Ian was standing in my office and I said, well, let's talk about hurricanes, right? Some people will say hurricane or the bad weather or extreme weather is driven by global warming. Global warming is driven by, us as individuals driving our cars too many times, or SUVs, whatever it may be. So are the hurricanes that we have or the extreme weather we have now really caused by us, right? I mean, again, if you could find enough scientists that would, and you can find them, I'm sure, to testify. Yeah, that's what happened. Well, there goes your issues with your act of God.
Right, because we've got this U.S. Supreme Court case that has the word exclusively in it.
Yeah.
So if we can find something that makes it not exclusively an act of nature, I think the act of God goes out the window.
Again, that's probably not reality of necessarily many cases, but it gives you an idea how people are going to probably play with this provision. Because again, I can tell you there are not a lot of cases that talk about it.
Right.
Maybe on construction, sometimes there's some of that, maybe because of, some really unusual weather conditions, but it's pretty rare. It just doesn't happen a whole lot.
Yeah, and I think whenever I'm really thinking about act of God, it's one of the earthquake, flood, tsunami, volcanic eruption, things like that really we can't do very much as human beings to influence that at all.
Yeah.
I think that's what really they're talking about in act of God.
So let's look at another terminology that you might see in contracts. It's called impossibility or impracticality, and it really bases the idea of it relieves a party from their liability or performance. But the impracticality means, or because of an extreme or unreasonable difficulty, expense, injury, or loss involved. Now, that doesn't mean just because your costs go up, say you contract to do something, but your costs go up, that I think you can rely on that necessarily. But that's part of it. An action is impossible in a legal contemplation standpoint when it's not practical, and an action is impractical when it can only be done at excessive and unreasonable cost. They don't define what that is. They just say excessive and unreasonable. As I was looking through these definitions and looking at some of the case law, it reminded me of a couple of cases that we've had recently where we had a client who said, look, I can't perform this contract anymore because the cost has just like tripled, right? I'm like, I don't think you can use that. I don't think you can
at all. I think that's just one of the risks that you take whenever you go into business, that cost might go up.
Yeah.
And you need to account for that whenever you're contracting.
And I've thought through that a little bit. I'm thinking through the judges. I think I'd have a hard time, or we would have a hard time going to a judge in North Carolina to say, hey, look, it's impractical for us to do this now because the cost has tripled. Like you think about fuel costs, maybe if fuel cost goes way, way up, I think they're just going to look at you and go, hey, you got to suck it up. That's your contract. I think. And generally it involves changed circumstances. And it's something that generally has to be unexpected, must have occurred, right? It's not something that you sort of know the risk of that's coming, but in this case, it's something that has to be unexpected. And the risk of the unexpected event must not have been allocated. That is, party A is going to have to take care of the risk for party B, because that shows that you're somewhat expecting it to happen, I think. The event must have rendered performance commercially impractical, and that's again from a Black's Law Dictionary standpoint. So again, that again, y'all might even see this kind of language in some of your contracts that you already have, and it's not something that we've dealt with a whole lot. So it's not something that you may have dealt with in a contractual standpoint very often. The frustration of purpose doctrine excuses a contractual obligation event in the circumstances when the objectives of the contract, that is the primary purpose of the contract, have been defeated by circumstances arising after the contract was formed. So again, you could argue, hey, look, no one knew the virus was coming with reasonable certainty, and that's frustrated the purpose. The purpose of the contract was to, make up something that, we can't do that anymore, right? The doctrine excuses the contractual performance. But again, these are just sort of defenses that you might be able to use, or you might hear from your customers maybe in dealing with some of that. So hopefully that helps us a little bit. So some things you're going to definitely probably see in some of these provisions is a notice requirement. And what does the contract provide? Does it require reasonable notice? Is it prompt notice? Is it immediate notice? These are words that we've seen through a lot of other provisions. And when did the event causing inability to perform begin? You got to look at the facts of the circumstances. Was it when the federal government, passed the first piece of legislation? Was it when the president said, we have a pandemic. It was when was it when the World Health Organization did something, right? I mean, there's so many different, in this case that we're talking about, but in whatever the circumstances may be, what triggers it, right? In North Carolina, is it when the governor made some proclamation? I don't know. I mean, it's just fact specific.
Yeah, I think people are going to argue it a lot of different ways.
Yeah. So again, not trying to not answer any questions, but it gives you something to think about that we're looking to. So obviously the UCC comes into play almost in everything with business.
Right, especially so this statute that we've got part of up on the screen, it deals with the sale of goods. I want to make that clear that doesn't apply if you purely provide services, but if you are in the business of selling some type of good to another person, this applies. So it has some excuse language in it. So excuse by failure of presupposed conditions. Basically, whenever something changes, this statute might be triggered. And like what James was just talking about, the seller can't have assumed the risk of the event. Performance must be commercially impracticable as a result of the event, and the buyer must be seasonably notified that there's going to be a delay or a non-delivery. And I looked at the comments to the statute and the annotations, and increased cost alone doesn't qualify here, nor does a rise or a collapse in a sufficient market. So just because the market conditions have changed, you can't rely on the statute. However, a severe shortage of raw materials due to some type of major shutdown would fall within this section. So again, the particular circumstances are going to be really, really important here. The why someone is not going to perform or is going to have to delay, that's going to be really important. And I would encourage, if someone is going to suggest that they either delay or don't perform, you get them to document in writing the reason why they're not going to be able to do it, because then if litigation does occur, you've got that to rely on if this statute is triggered. Any thoughts on that one, Jim?
Yeah, that's pretty straightforward, thankfully. So the question is, how, is this going to impact accounts receivable? Is this going to impact cash flow for customers? And how's that going to do? What impact will that have? And so, we were just thinking, like, for example, the customer says that they have not worked and can't pay. Well, what happens? What do you do? And I don't think it's changed from a lot of circumstances, other than the fact that you say, hey, look, we got to get this thing taken care of. How are we going to get it taken care of? How are we going to get it paid? And the customer says that they can't perform due to the conditions that they've incurred. Obviously, we would say develop a plan of repayment early and call them, talk to them, get on the phone, talk to them early, document the plan in writing with an agreed payment plan. If you can get a confession of judgment, do that. Obviously, many of y'all know you're much better doing that. We would encourage you not to do your own confession of judgment, because I've seen them, unfortunately, when they get changed enough that you can't even, there's nothing really to file on because it doesn't follow the statute. But that's just an ideal suggestion. So, and also look at security interest and or lien rights. And if you have those, make sure you record them. We've had quite a few. Actually, we were very surprised. I think we filed maybe 3 or 4 liens in the last 2 weeks, just to try to get secure stuff or get stuff secured so that in case it goes bad, obviously there's sort of a gut feel there anyway. Look at your contractual notices, make sure you all are complying with those. Ian and I have got a case now where the contract was actually terminated, I think in January of this year. It has nothing to do with the coronavirus issues at all. And we got a letter this week from opposing counsel in trying to negotiate, and I think we're going to be able to get it resolved. But he threw in a provision that said, that they are excused because of the coronavirus issues, and that they should be excused from performance for that. And I'm like, that has nothing to do with that at all.
Yeah, I'm concerned we're going to see a lot of that. So that's why looking at the timing of when somebody's business really started going downhill, if they're not able to pay, that's going to be important.
Yeah. it was interesting when I talked to the attorney, and thankfully we know him really well. We have a great relationship with him, and he and I get along really well. And I said, that has nothing to do with this. And he's like, yeah, I know. I just thought I'd throw it in. I think we're going to see that. I mean, that's just, he's taking care of his client, even though it's not legitimate and an excuse. And I don't think he would do that in front of a court because of the timing. But again, that's something to think about. Also, we need to be proactive in reaching out. So we would encourage you to reach out to your customers and work to make sure that you're a priority for payment now before it gets any worse. Hopefully it's not. I've only heard of one job. This was about 2 weeks ago. I have seen some documents. I haven't heard of the jobs, but have been put on hold. At that point, it was primarily because the stock market was bouncing around. But we have heard some jobs have been put on hold temporarily because of the coronavirus issues, and eventually that's going to impact accounts receivable by projects, hopefully not overall.
Yeah, and I think permitting is causing some of those problems, and one of those slides we looked at mentioned permitting.
Yeah. So as I understand, at least Wake and Durham, I think permits are still going forward, I understand, and inspections still are.
And that's my understanding as of today.
So hopefully that continues. Hopefully that, because we all know if that slows down or stops, it's going to mess up the whole system for a little bit. But hopefully that won't stop. We encourage you to look at the contracts with your customer, devise that plan, look for those defenses early, develop a plan for repayment. And the other question, are statute of limitations an issue? And it's something that you need to keep in mind. The biggest one that many of our clients will hit early would be the lien claim statutes or payment bond claim statutes, stuff like that. But because most of the contractual stuff is either 3 or 10 years, so that's probably not going to be that big of an issue. So we did just get a question that says that there, in general contractor, is there an ability to request extended general conditions for delays and or stoppage of work? And I think the answer would be it probably depends on how you got to read your whole contract to get an idea for that. And again, there may be a legitimate reason to ask for that.
Yeah, and if the alternative is either was the whole project getting slowed down or shut down or litigation, it seems like given everything that's going on, people ought to be a little bit reasonable as long as there's a legitimate reason behind the request.
Yeah. I've got a friend and client who does upfit commercial spaces, and he was saying there were some doctor's offices and hospital. It wasn't like in a hospital, but it was a clinic type thing connected to a hospital that they were like throttled down to get it done, but other projects had been slowed up a little bit. They hadn't stopped, they just slowed up some and it was primarily concern of being in the building. But to go back to the question, I think it really depends on your contract, how it's worded. And I hate to say you got to read the whole thing and get an idea. But again, what kind of contract is it? What kind of provision? I mean, what kind of space is it, right? What can you not work, right? I heard one guy say the other day that they were limiting trades on the job. That is, you couldn't have multiple trades on the job, and that'll slow the job down. The other thing I would say is look at the direction from what the owner is saying. If there's a contractual provision, saying, hey, look, we don't want you on the job right now because of this, and again, I think there are a lot of those things that come into play, but I think there's probably a more legitimate reason to ask for it than not. And the other thing I would say is go ahead and ask now. Don't wait.
Yeah.
Don't let that become a festering situation. So let's look at attorney's fees just for a little bit. If the contract is enforceable and there's an attorney's fees provision in the contract, that certainly can be enforceable. As many of y'all know, there's a provision 6-21.2 comes into play, and then 6-21.6. So there's always an attorney fees issue that y'all probably hopefully have it in your contract, and you can hopefully utilize that if you have to. And a lot of times that's in court settings, and sometimes negotiation.
Right. And one thing that's not on here for the contractors is the lien statute and your ability to recover fees under that.
Yeah.
Unfortunately, though, there's no way to go back and retroactively add an attorney's fee provision to a contract. So it's just something you need to be looking at going forward and making sure if that's not in your contracts that an enforceable fees provision finds its way in there.
Yeah. And just one other little thing, we'll give you all a little bit of an update. I mean, some of y'all know this already, the status of the North Carolina courts, and this is changing a little bit, but as when we wrote this yesterday, most courthouses are open. There are significant limitations. I think most of the courthouses have said they don't want the general public coming in. The clerk's offices are open and accepting filings. They're accepting new suits, liens, and so forth, motions, and so forth. They're having, some of them have limited hours, like in Wake County. I think they're open from 1 to
5.
I think they have limited staff. As of, when was this it was in March when the Chief Justice said all motions, hearings, and trials are currently postponed until April 17th. That's what they're telling us at this point. We're looking at all the things going on. We're both thinking that's going to be extended out, but we don't know that yet.
I'd be surprised if it's not.
We're trying really hard to ask the courts to go ahead and schedule stuff for June. And I would imagine law firms that are working are probably doing the same thing. But so we're asking, and we haven't gotten a response yet, but I know we've sent probably a handful or a dozen or so already this week to the clerk's offices, the trial court administrator's office, to say, hey, look, put us on for June. I don't know what's going to happen. I don't know if everything ahead of us gets put on the calendar first, or they just start putting you on when you get asked, to get put on. I don't know.
I don't think they know yet, to be honest. I think they're still trying to figure that out. Thankfully, some things that we're able to do whenever litigation has already started, like depositions and mediation, we're working on ways to be able to do that remotely so that cases that are ongoing can continue to move along.
But I think the logic, unfortunately, is we're all going to be dealing with delays at court. Some of them are legitimate, some of them are not. Some of them are going to be made up, but it's just part of the process. You and I were talking about, from a standpoint of, this is just my gut feel. It'll be interesting to see what happens when we all get back in the court and someone has a reason why they haven't done something during the coronavirus issues. My gut feel is the judges are going to be a little bit sympathetic to some extent.
Yeah, I think it's going to be virtually impossible to hold on to entries of default or default judgments for the next several months.
Yeah, it's just something we're all going to be dealing with. But hopefully that makes sense to you. And again, if y'all have got questions, please let us know. You can send them to us by email. We'll be glad to respond to those. If you just have questions in general, please just reach out to us. Let us know. We'll be glad to help you. And we just are, again, delighted to be able to help. Hopefully this helps you and get you some information. If y'all haven't connected with us on social media, we'd love for you to do that. We send out stuff by email and also on social media. And we just have an honor to represent you guys and to help you all and hopefully get some information to you. So thank you for participating. And
absolutely.
Look forward to seeing y'all soon.
Yep.
Be safe.